In Chapter 10, we're going to look at the psychology of false confessions. So let's look at confessions in general. We have confessions in religion, and religious confession is the process by which adherents acknowledge and disclose their transgressions. The purpose is to cleanse the soul and deter further wrongdoing. Now, confessions in psychotherapy are often looked at in terms of catharsis. So, natives of North and South America believe that physical and mental purity was achieved in part through elaborate confession ceremonies involving shamans and witch doctors. Freud also observed that patients often feel better after purging the mind. And this idea of catharsis is traceable to Greek tragedies, in which incidents and plays arousing pity and fear would vicariously purge, purify, or morally re educate those watching. It's also been used as a cleansing or purification process worldwide through healing rituals and confessions. And some forms of therapy today still emphasize that discharge of emotions. Recent research also does confirm that there is a therapeutic effect of opening up and letting go. A study of women who had undergone an abortion and talked about it to an experimenter were later less disturbed by intrusive thoughts of the experience. Another study found that men with HIV showed a more rapid spread of infection and greater rate of mortality in those who kept their orientation and lifestyles a secret. Now, in criminal law, we're concerned with whether a statement is authentic and voluntary. Was it procured without undue pressure and with a knowing waiver of rights? And so the criminal justice system does have guidelines for admissions of confessions at trial. And preliminary hearings are often held to determine if the confession is voluntary and therefore admissible. Now, in 1936, in Brown v. Mississippi, there were three black men arrested for murder, and they were not allowed to consult with an attorney and were subsequently threatened, beaten, and tortured. Then all three signed a written police confession. And the Supreme Court reversed this, saying that the police violated due process, that evidence procured through physical torture cannot be admitted into evidence at trial. In 1966, in Miranda v. Arizona, the Supreme Court said, unless the accused is advised by the police of his constitutional right to remain silent and obtain counsel, all self incriminating statements are inadmissible in court. Now, most confessions are not spontaneous, but rather the result of negotiations with the prosecution, 20% of which are later recanted. So, thinking about the psychology of false confessions, it's pretty common for investigators to use deceit and psychological manipulation to gain a confession. They might tell the suspect they have evidence linking them to the crime or try to minimize how serious the offense is. In 1908, Munsterberg believed that in some instances, the innocent confessing person actually believes themselves to be guilty, and that those confessions occurred even in defendants who were, quote, psychologically normal. So there's three types of false confessions. The first is voluntary false confessions. These are self-incriminating statements purposely offered in the absence of pressure by the police. This might be to protect a friend or a family member, or sometimes because the person desires notoriety. The second type is coerced compliant false confessions. These suspects confess despite knowing their innocence because of extreme methods of police interrogation. This could be tortures, threats, and false promises. In 1940, in Chambers v. Florida, the defendant had undergone 5 days of prolonged questioning and other factors that fell just short of physical violence. And this elicited concerns that confessions given by defendants could be false. In 1963, in Haynes v. Washington, the defendant was refused telephone contact with his family and attorney, but told that he could contact them as soon as he made a statement. So the Supreme Court said that the confession was coerced by the fact that the defendant's will was subverted in an atmosphere of substantial coercion and inducement created by promises made by interrogators. Now, the third type is coerced internalized false confession. These are suspects who are innocent but have come to believe they committed a crime. This could be due to anxiety, fatigue, pressure, confusion, or highly suggestive methods of police interrogation. And these confessions can actually alter the memory so that the original memory is irretrievable. It's also possible to implant false memories of childhood experiences. So, why do false confessions occur? Well, The authors talk about what they call station house syndrome, and this is the generation of internalized false confessions. And it's a result of the heightened suggestibility and suspects being interrogated by police. Some individuals are more prone to interrogative suggestibility due to social isolation, high anxiety, generalized poor self esteem, unassertiveness, and low levels of intelligence. Some suspects confess because interrogation convinces them that confessing is the most rational choice. They believe that the police have strong evidence and that if they confess, they'll get a lesser punishment. They want to end a stressful interrogation, or they might even believe they can't convince the interrogator that they're innocent, but later on they'll be able to prove that they're innocent. False confessions can also result from self perception. So, making false confessions can alter the recollection of our past behavior if that confession is given in the presence of cues previously associated with telling the truth. Now, demand characteristics of interrogations also increase the probability of making a suspect confess. How long is the interrogation? The longer an interrogation is, the more likely we are to start focusing on short term gratification and lose sight of long term consequences. Interrogation rooms are also set up to be unfamiliar. There's no extraneous sound, no windows, and it's minimally furnished. Police also often try to establish a superficial friendship or exhibit unexpected kindness while trying to appeal to the best interest of the suspect. They may also note inconsistencies in the suspect's statements and confront the suspect with evidence and use trickery and deceit. Interrogators may build on the sense of hopelessness and use strategies to convince the suspect that given irrefutable evidence, confessing is their best option. They might do this by minimizing the seriousness of the situation or shifting blame onto others, or by maximizing, frightening the suspect by exaggerating how much evidence there is against them, or stating that the interrogator knows they're guilty. Now, the stress inherent in any police interview combined with isolation, minimized sensory stimulation, and complete control and domination by the interrogator results in an increased likelihood of a wide range of behavior and physiological disturbances, including loss of contact with reality. So, while many people would say they would never falsely confess, pretty much anybody can be worn down. Now, what does the Supreme Court say about confessions? In Brown versus Mississippi, we know that a conviction was overturned because the person had been physically tortured into confessing. So, the first half of the 20th century, we see cases that are very clear instances of coercion. In 1944, in Ashcraft v. Tennessee, a confession obtained towards the end of a 36-hour period of practically continuous questioning under powerful electric lights by relays of officers and experienced investigators and highly trained lawyers. Now, 4 years later in Ward v. Texas, they voided a conviction based on a confession from a subject who'd been arrested illegally in one county and brought some 100 miles away to another county. And they were continuously questioned over 3 days while being driven from county to county and being falsely told of a danger of lynching. And in 1960, in Blackburn v. Alabama, the Supreme Court recognized that coercion can be mental as well as physical. So, for about 30 years after Brown versus Mississippi, confessions were examined looking at the totality of the circumstances. The court was busy balancing the view that police questioning of suspects is indispensable with the idea that interrogation process is not to be used to overreach. In 1961, that test changes to voluntariness. The confession should be essentially free and unconstrained. In 1966, in Miranda v. Arizona, we moved to the self-incrimination standard. We can't use statements that are made in custodial interrogation unless we have shown that that person has been told and informed of their rights to not incriminate themselves. And basically, the Supreme Court here is saying that police interrogation by its very nature is coercive. Now, this questioning also applies to once you have been taken into custody or otherwise deprived of freedom and of action. And once you assert your rights, they must be respected. So if you say you would like to speak to an attorney, the police can no longer question you until you have at least met with an attorney. And in Edwards v. Arizona in 1981, the Supreme Court also said that includes that you cannot initiate questioning until the suspect has met with counsel. Now, there is a public safety exception that comes from New York v. Quarles. In this case, the police were chasing a suspect who had a gun in his hand, and when they caught him, he no longer had the gun. He had run through a crowded marketplace, so they asked him, "Where is the gun?" They were able to ask that because that gun is loose. It's free in a space where somebody might get hurt. So, what role can forensic psychologists play here? Well, the biggest role they can play is educating people in the criminal justice system about things that make individuals vulnerable to false confessions. That includes everything from diminished capacity, mental impairment, deficient intelligence, fear, confusion, suggestibility, low self esteem, anxiety, and being a minor. To situational factors: duress, coercion, isolation, lengthy interrogation, deception, and questionable interview techniques. They can advocate for the mandatory recording of interrogations. This decreases the number of false confessions and increases the reliability of those confessions as evidence. And the judicial system as a whole needs better education about this. We should focus on the fact that our goal is to elicit the truth, not to secure a confession. Investigators should assume a disinterested role rather than an adversarial one. And prosecutors should be careful to evaluate a confession's trustworthiness before charging.